Good afternoon. This is sWomen in Law on the 11th of May 2026. We've just been to Downing Street to deliver our petition requesting inclusive mediation. And here is the Honourable Dr Jocelynne Scutt AO to add a few words regarding inclusive mediation.
Here we are at the Cabinet War Room. Our message is this: there are grounds for judicial review in terms of the decision most recently made by the Secretary of State for pensions, work and pensions. Those grounds are really clear. First, there's been a failure to consult with relevant parties. The government has restricted itself to consulting with a company named WASPI, and it has left out all other women who are not represented by that company. That company has acknowledged that it represents 7% only of all the 3.9 million women impacted by the 1995 State Pension Act change and subsequent legislation which impact on the cohort of women born in the decade of the 1950s. The government, in that announcement, the decision that the Secretary of State made, was referent only to the 7% of the 3.9 million women. That means that there's been a failure to consult with all women that are impacted. There's been a failure to take into account the impact on all those women, and there's been a failure to take into account the voice and the rights of those 3.9 million women beyond the 7%. That's one. Two, there's a bias or a reasonable apprehension of bias in that the government has restricted itself, again, simply to consulting with WASPI Limited, the company that represents 7% of the 3.9 million women. That means that those remainder, the beyond 7%, the 93% of women, would rightfully have an apprehension that the government is biased, and it is biased against them because it is not taking into account their views. It's restricting itself to the 7% of women represented by WASPI Limited, a company to which one must pay fees in order to belong. Furthermore, there's been a failure to take into account relevant considerations. The relevant considerations are that embedded in the failure of government successively to notify women in the 1950s cohort of this change to their pension age, embedded in that failure is a discrimination on grounds of sex and on grounds of age, and potentially indirect discrimination on grounds of marital status. Now, that was all explained in the judge's report that came from the sWomen in Law People's Tribunal that was held to look into this issue. Again, further, material that is relevant, that has not been taken into account, are the international obligations that the United Kingdom government has to all women. In 1981, the United Kingdom government signed the Convention on the Elimination of All Forms of Discrimination Against Women, SCR. In 1986, the United Kingdom government ratified SCR, the Convention on the Elimination of All Forms of Discrimination Against Women. That meant that the government was saying that it would introduce into domestic law the provisions and the principles and the practice of SCR. It has never done that. The former government used as an excuse, number one, that they said Wales, Scotland and Northern Ireland had to agree that it should be put into domestic law. Well, that argument, I'm afraid, failed, because Scotland, Wales and Northern Ireland are considering putting the CEDAW into their domestic law. And of course, Scotland was told, when they sought to do that with the Convention on the Rights of the Child, that they were acting outside the terms of their authority as a government of Scotland. So that argument, anyway, falls. The next argument that the past government used was that, well, we've introduced CEDAW anyway, and they stipulated in that regard the Equality Act and the Human Rights Act, which is absolute nonsense. I'm afraid it is nonsense, because those acts do not introduce the provisions of the CEDAW, which go to women's sex-based rights, and it goes beyond the issues that are adumbrated in the Equality Act of 2010 and the issues that are adumbrated in the Human Rights Act of 1998. Therefore, the government has ignored relevant considerations, their obligations under international law. The government has also failed in a failure to acknowledge that what happened here is that women paid into the National Insurance Scheme, and they have never got out the proper equivalent of money that they paid in. When the 1950s women were paying in, they were paying in order to support people who'd reached pension age. And the understanding under the National Insurance Scheme is that they were paying in to support that group of people, and that when their turn came to take pension, they would actually be paid out of the National Insurance Scheme. And ironically about the National Insurance Scheme, let me say further, we know that Robert Maxwell was criticised, and rightly so, for having taken pension monies out of a private pension fund of which he had control because he was in the relevant business. Now, what we have had is successive governments that have purloined funds from the National Insurance Scheme and used it for other purposes than paying out pensions. And so why are they not being criticised for having done that? Because by having done that, they now are in the position to say, allegedly, that they cannot pay out to 1950s women the money that should have been paid out to those 1950s women. What we are living with is a situation where 1950s women suffered discrimination in failures of equal pay. They did never get equal pay. It didn't matter that 1964 there was an Equal Pay Act, because the 1950s women did not really benefit from that. And even now we know there is no equal pay. So therefore 1950s women suffered discrimination in terms of lack of equal pay, and they're now suffering discrimination in terms of lack of equal pension rights, and the government is saying effectively, we do not care. Well, CEDAW in law does care about 1950s women. CEDAW in law does care about the 3.9 million women who have been impacted by this change that ignored government rights under CEDAW, because in 1995, when the State Pension Act was passed, which brought about this change initially, that act was passed in repudiation, effectively, of the obligations that the government of that time had in relation to CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. The United Kingdom had signed more than 10 years before. It had ratified almost 10 years before, and yet it still went ahead with the 1995 State Pension Act change that impacts on sex grounds, on age grounds against women, directly in contravention of the Convention on the Elimination of All Forms of Discrimination Against Women. Now, we do know that Parliament is sovereign, and it is allowed, unfortunately, to pass laws that do abrogate people's rights, but it should not compound the problem by failing now to recognise 1950s women have rights. 1950s women's rights have been abrogated. 1950s women's rights need to be reaffirmed, and that can be done not by launching legal action. As I said, there are grounds for judicial review. That's absolutely clear. But why launch legal action with all the money and the stress that involves, with no assurance of any positive outcome for 1950s women, when one can institute mediation when there is a dispute without having instituted legal action? And it's absolutely clear there is a dispute. The government cannot say there is no dispute. There is a dispute, and this dispute has been ongoing for too long. Therefore, what CEDAW law says is to the government, come to the table. There's a 500 affirmed mediation team at the ready to undertake mediation in neutral terms between government and between the groups that represent the 3.9 million women. Those 3.9 million women deserve a place at the table, and that place at the table should be affirmed and acknowledged by government. Otherwise, the government is saying cock a snoot to all the women, not only the 1950s women, but to all women of this country, because what it is saying, we do not care. The rights of women are irrelevant to this government. The government needs to come to the table. No, government needs to engage in mediation. It is only in that way that the 3.9 million women can have their rights affirmed and properly consolidated. Thank you.
Thank you, Dr. Scutt, for your years and years of pro bono work advocating for the legal rights of 50s women. Thank you.